A pleasant day and a warm welcome to your favorite show, Law and Order. Not knowing the law is not an excuse. There are many scenarios knitted around certain problems, and even when dealing an ordinary life, we need to learn some aspects of law. So today, from this series of programs, we are going to focus on land law, which is one of the most essential areas that each and every one should understand. So to do the honors with us, we invited a thorough gentleman to speak on these matters. He is none other than Mr. Sapumal Bandara, attorney at law. Thank you very much, sir, for attending our discussion.
Thank you very much, Charitha, and thank you very much for inviting me to your program. Thank you.
So today, sir, we are on to Law and Order program, and we are going to discuss the land law, which is one of the most essential things that a person should understand. So to expose the topic, what is land law?
Charitha, land law can be simply defined as the law relating to lands and immovable property. However, this simple definition is not complete. Why I say that is, Charitha, because the land law contains lot of details, lot of information and lot of laws. Whereas if I say that it has a gamut of information and details, where there are statutory laws, series of statutory law and thousands of case law, and also opinions of jurists explaining these legal principles involved in this land law. So if you ask me to define the land law in a very simple or in the literary manner, I would say that it is the law which is applicable to lands and other immovable property. But Charitha, honestly, you cannot simply define land law in that way, because it involves a lot of information and details.
Right. So you focused on a word, immovable property.
Yes.
Can you just expose that word as well?
Yes. Now, immovable property is property where it is land or any other structure permanently attached to land. So now the property is classified in many ways in terms of different legal systems. Now, in terms of Roman Dutch law, there is a classification of property. And in terms of Canadian law, there is a classification of property. And in terms of English law, there is a classification of property. However, we can commonly agree upon that, for the especially for the benefit of our viewers, that in simple sense, property can be classified into three simple categories. One is immovable property, the other one is movable property, and the other one is intellectual property.
Right.
So this immovable property is basically the lands, and those are permanently attached to the lands. If I give you a small example, now obviously now we understand that lands are immovable property because it's not movable.
Yes.
And if someone construct a permanent building on a land, so that building or the construction is also becomes immovable because it's permanently attached to the land.
Right.
And not only the buildings, now take for example the trees or whatever rooted to the ground or to the earth, as long as they are not movable, are considered as immovable property. So the land law applies to all these immovable property, lands and other objects which are permanently attached to the lands.
Right. So moving ahead with your explanation, now you said simply there's a land, it's already immovable, and if we are going to erect or put up a building or something like that, that is also immovable. Trees planted, immovable. Then what about the furniture or something like it's inside the house?
Yes.
We buy them for the purpose of modifying the house.
Yes.
So aren't they? We simply can say that chair can be moved out of the house, but it's like it's a part and parcel of the house where the furniture and the other equipment deals with. Aren't those immovable?
Yes. No, they are not immovable, because now take for an example the chair that you are sitting. So you can move it inside this house or outside the house. So you can move it to anywhere as you desire.
Right.
So it is, so therefore in the nature of the property, now when you categorize or when you classify property into movables and immovables, the main aspect or the main concern is about the movability,
Right.
where you can change the position of your chair at your wish, but not the lands and the other permanent structures.
Then, sir, adding something more to that,
Yes.
now these two chairs that we have been seated, we can move it here and there, and we can set up the studio setup while making some movements of these equipment. But think that this is permanently fixed, like nailed. We can't move it. To the purpose of moving this thing, we have to remove the nails and we have to employ some of the labor, hard labor. Is that immovable?
Yes, as long as it is attached to the ground, attached to the earth, it can be considered as immovable. You know, what is most important is the intention of the person who controls the property. What is the intention of the controller of the property? If the intention of the controller of the property is to be permanently fixed it, even though this chair is permanently fixed to the floor, and then it is part and parcel with the floor. Soon after you remove the nails and detach it from the floor, it will again become immovable property.
It's dynamic and a vast area that we
That
can
is so.
Yes.
That is
So
so. It's
in
very
the
vast.
nature of that explanation, that's property when it comes to movable, immovables, like depending on the nature, scope, and you said that the intention of
Yes.
the owner of the property, it depends and it differs.
Yes.
Right. So when it comes to those explanations, we feel like the land is owned by myself. Some people say, what is ownership?
I think that is a very pertinent question, because ownership is one of the fundamental principles in land law. Ownership you can simply define as the control, your control over something. Now in Roman Dutch law we consider things, where if you have some degree of control over a thing, it is called, that is your ownership. But now it is, as I started this conversation by defining land law, this is also not a simple definition. You cannot give a simple definition to the term ownership. Now let me tell you some of the characteristics of ownership. So it will definitely make easy. It will become more convenient for you to understand the concept of ownership when I describe you the characteristics of the ownership. Now, one essential characteristic of ownership is that if you own a property, now let's say let's focus on lands. So if you are the owner, you have the freedom of disposal. That is, you have the freedom of, you have the right of disposing the property, alienating the property. Simply that you can sell that property to another party on valuable consideration. That's on financial gain. You can transfer the property to a third party, and you can gift it to a third party. So because that you have the control over that, you have the absolute right to transfer your property to a third party. So that is one aspect, that is one characteristic of ownership.
Right.
A person who is other than an owner cannot sell, cannot gift. Even though he attempts to do that, in legal sense it would be invalid, because he does not have the required capacity to transfer or to dispose.
Right.
So that is one aspect, that is one characteristic of ownership.
It is not merely the possession.
Possession is another aspect.
Right.
Where, good that you mentioned possession. So the other characteristic is the possession.
Right.
So why I say that mere possession is not enough, because a person other than the owner can possess, but he may not have the right, he does not have the right of disposal.
Right.
He does not have the right of disposal. The possession is the enjoyment. Now, if I have land owned by me, I can construct on that land. I can cultivate the land. So nobody would obstruct me, or nobody would question me of my cultivation or my construction, because I am entitled to enjoy my land. So I can earn profits, so I can cultivate something on my land and I can earn profits. I can put up a house to dwell, and I can put up a commercial building, and I can lease it out to third parties and generate income out of that. So there is no encumbrance. Now the difference is, sometimes the possessors may not be the owners. Now for an example, that if I am your tenant, that you are the owner, I am on your house on a tenancy agreement. So I am not entitled, or I am not legally empowered to dispose this property. So all these requirements or characteristics are interconnected. That's one disposal. And also destruction. So if you are the owner, you can destruct the property. Now say that if you have a house and you feel that it is now old fashioned, and you need to demolish it and you need to construct a new house, a modern house. So you are free to, you are at your liberty to destroy or to destruct your old house and construct a new house on your land. So that is because you have that absolute control over the property. So the ownership is always the control. So the control is like, has many facets. One, disposal, other one is enjoyment, and other one is destruction. So those are the main elements of
when considering ownership, if those things can be exercised by the particular person, he is the owner. Otherwise, if he is in possession, for example, like it's my land, and if someone is there like under rent or lease agreement, he is not the owner, but he can possess the land. It's like theft being described with possession and ownership. Same as the land, and the audience, they might be confused, like when it comes to explaining at a certain moment we speak about land, but in your explanation you say about immovable property. Land is also an immovable property, so he's been a counsel and you can't say only confined to a particular word. That's why the explanations are directed like that. So as that thing happens, we explained already what land is, what immovable property is, for your clarification. And so we discuss about ownership and those things. There might be certain modes of acquiring ownership as well.
Yes. There are many ways of acquiring ownership. The common way of acquiring ownership is by purchasing. So purchasing a property, by purchasing a land would give you the ownership. And if somebody gives you a land, then you will become the owner of the property, and you may inherit a property by your predecessors. And also by way of a court order, you can acquire ownership, and also by way of a state grant, you can acquire ownership, and also by way of prescription. So later in this discussion, I will explain what is this prescription is. So you can acquire your ownership in any of those ways. So if I say that by purchasing or by way of a gift, it has to be by way of a notarially executed documents. In order to become a owner of a land parcel as a purchaser, you must enter into a valid contract or valid deed with the seller. So this that applies to gifts also. So in terms of prevention of frauds ordinance, immovable property cannot be transferred, alienated, gifted, or even you cannot enter into any agreement with regard to immovable property unless such agreement or transaction is by way of a notarially executed document. So now, if it is not a notarially executed document, even though you pay the purported owner the money that he has asked, you will not become the owner if it is not by way of a notarially executed document.
Notarial execution is mandatory.
It is mandatory.
Are there any alternative ways? No.
There are no alternative ways as far as section 2 of the Prevention of Frauds Ordinance is concerned, but I will tell you at this juncture, because we have seen some of our clients, they are in possession of some informal documents. Some people believe that informal letter would sufficient,
and they believe honestly that signing on a stamp would do.
Exactly.
Yes.
Exactly. And they come and tell us, now sir, look here, this person has signed on a stamp,
Yes.
and he has categorically admitted monies in relation to the selling of this land,
And
but
some
those are
with
not sufficient.
heavy words and like terminology, they use certain letters, and they fall in trouble.
So it has to be by way of a notarially executed document. And the other one is by inheritance. Now, inheritance is another mode of acquiring the ownership, where now your mother or father, like maternal, by way of maternal inheritance, by way of paternal inheritance, you can inherit the property. So you will become a owner because of your predecessors. So by way of inheritance you can, and also by way of a court order. Now, by inheritance is now a deceased person's estate passes to the next generation or the successors depending on the law that he was governed when he was alive. So if you are governed by the common law of the country, soon after a person dies, remaining spouse will get half share of the property, and the balance half share would go to children. And if you are governed by the Canadian law, that scenario is entirely different. Where the wife does not get half share, she does get at either life interest or maintenance of the property. It is depending on, because in Canadian law there are two types of property.
Yes.
One is inherited property and acquired property. So in relation to your acquired property, wife gets life interest, but in relation to inherited property, wife only gets maintenance of that of maintenance out of that property. So it is little complicated. So this inheritance is also a mode of acquisition of ownership. And then court orders. Now, say for an example, by way of a court order.
Yes.
By way of a court order, you can become an owner of a land parcel.
Right.
And also that prescription, as I tell you earlier, it's also a important legal principle, where in terms of the existing law of the country, if a person can prove long, uninterrupted and adverse possession to a land parcel, he is entitled to claim the land against the paper title holder or the actual owner of the land. That is a little complicated principle, but now in terms of the prescription ordinance, if a person continued to be in occupation of a land for a period of 10 years continuously against all rights of the owner, then he can claim that he has prescribed to the land.
Right.
So he does not have a deed, he does not have a court order, he does not have a state grant, he does not have inheritance, nothing. But
uninterrupted
adverse possession for a period of 10 years would establish his ownership. Right. So those are the methods of acquiring ownership.
So moving on to a small context, like this will be a small story. For example, like if a person is there, so his father has some inherited property from his grandfather. So grandfather has died and he's no longer like in existence, and his mother like this will be a complicated story, but what I'm going to emphasize is, for example, there are 3 generations. From the topmost generation, they had some property, they had the particular documents where they have owned the property, but to their children, that means the second generation, they haven't given any of those what do you call, legal documents in writing, and they feel that, right, oh, my father is there, now I get my get his property. And like to the third generation, like what I'm going to explain is that from generation to generation, until like 4-5 generations go on and proceed, they don't have valid documents, but the forefathers land is there. So they claim that, all right, this property should be divided like this. Can it be simply divided?
Well, if on mutual agreement, it can be simply divided.
Right.
That is, if all parties agree, to divide in an amicable manner, then it could be divided among the parties. Now, Charita, the thing is, now what you were in your small scenario that you explained, now this happened frequently, where now we have seen often, especially in rural areas, where people do not execute deeds or last wills before they die. In certain occasions, people execute last wills. So, if a person executes a last will, then his succession would be decided based upon the last will. Right. On proof of last will, whoever he had been named as his successor would get the estate.
Right.
However, if a person has not leave or left a last will, then the property will be automatically vested with the lawful successors. So, it is inevitable, and there is no prohibition, even if there is no testamentary action instituted.
Right.
By operation of law, soon after the death of the of a person, his property would devolve on his lawful successors. So, sometimes generations may not execute deeds. So, this happens. This happens frequently. So, after third or fourth generation, then these people, the third generation, they opt to divide this property among the current owners. So, then they have to either amicably settle their dispute, or they have to go before court to partition the land.
Final question, sir. When such inheritance has been proceeded to 4-5 generations, the fourth generation honestly believing that this land belongs to me, executing a deed by notarial execution and selling that property, will the buyer fall in trouble?
Yes, I think this is a very good question again, because there are certain precautions that you must take before purchasing a land, because nowadays it's very risky to purchase lands, because there are a lot of rackets and lot of underhand deals are there. But now what you say is, yes, now if I am confident and I'm sure that the chain of title is correct, yes, I can purchase without a problem. But the only thing is, now if I purchase a property without a proper division, then I might have to take the matter before courts to get that portion partition.
Right.
So, you must be cautious when you are purchasing a land where if the predecessor's title is not clear or not divided, then you may at a risk of resorting to legal remedies.
Legal remedies, right. Okay, so we had some interesting, insightful exchange of ideas, and the audience might be having a good exposure relating to land, and we'll be having some further programs on this particular topic discussion. So thank you very much for watching us, and thank you very much, sir, Mr. Sapumal Bandara, attorney at law, for doing the honors with us for today's program.
Thank you, right. Thank you very much.
So stay tuned with Law and Order. We'll be there with more discussions for you all to get aware about the law.
That he has accepted this